Well, hello everyone. So cool. We've got quite an international crowd today. I'm looking at where did I see Greece, Copenhagen, Italy. Welcome everyone. All right. Can somebody put a 1 if you can hear me just to make sure? I hate asking every time, but I have no way to know if you do till I see some response. All right. Thank you. All right, so let's just jump right to it. So yesterday we had a mountain of documents filed. I don't know if you guys got to see them all. It was motions to compel, motions for protective order, all kinds of things. There was a lot of interesting stuff. There was a lot of stuff that made me mad, and there was a lot of stuff that was just really juicy. And for one, Blake got caught asking for medical information that she shouldn't even have access to. And Ezra really messed up putting that in there, and they got called out for it, of course, but we'll get to that one later because that was one of the ones that really made me mad. Like, stay away from people's medical conditions. They've already doxed Jed Wallace's medical condition. They have put addresses and phone numbers out there. A lot of things made me mad this past week. We had arson at Steve Sarawitz's house. We had his college-age daughter threatened with kidnapping. I mean, just can you imagine? Just some really we found out that Jennifer Abel and Melissa Nathan, as well as Justin, have all been receiving death threats. I mean, for Blake Lively, people, why are people doing this for Blake Lively? She's a millionaire that's had a bodyguard around her since she was a teenager. She doesn't need you out here doing this much, bringing actual harm to real people because you're enamored by some movie star. It's crazy, but this stuff has actually been happening, and a lot of it, because some of the things that came out this week, everything we say about Blake and Ryan, we have actual footage of them doing or saying what we're saying that they did. It's years worth. I had no idea these people were so awful. And it's funny because this stuff was always out there. We just weren't paying attention. The idea that we had of who these people were is just, it does not match up with what we've seen now that we're actually paying attention. So they've been digging. I mean, they've got an ex-CIA guy, for heaven's sake, trying to find something on Justin. The worst thing they could come up with was toxic positivity. That's it. So this past week, what have I seen? I've seen them take clips of something and distort it and twist it, actually just make up lies about him having conversations on Zoom. Oh, from France. Hello from France. Um, just making up stuff about him talking to minors inappropriately. None of it's true. None of it has actual proof, but it doesn't stop anyone from spreading it, believing it. And it's that kind of garbage that provokes these people who are unhinged enough to go and set someone's property on fire or threaten their children. So the people that are putting these false statements out there, they're just as much to blame as the ones that they provoke to do this stuff. But anyway, that's not the topic of today. I'm just getting carried away because I was so mad. I actually had recorded an episode and I played it back to edit it, and I was like, no, you're just too mad. You got to delete this, try again later. And so that's what I did. I waited. So I'm going to try to stick to the topic. Now, I want to say, please don't feel bad. I get really distracted with the chat, and then I get all these comments about all the interruptions during the episode and wanting me to go back and do the pre-recorded so I don't get distracted by the chat. So I appreciate you guys all being there. And like at the end of the episode, just keep track of any questions that you have, and we'll come back to that at the end. So, but don't think I'm just ignoring you. I appreciate all of you being here, but I'm gonna try to pay attention to the actual material and not get distracted by the chat. So, in these documents, Ezra, she was her usual unnecessarily nasty self. And then Mitchell Schuster or Brian Friedman, whoever it is that's actually writing these, it's always Mitchell's name that comes first. So I'm not sure, but their witty spice, I just love it. It's just perfect. But Ezra, she hasn't been able to sort out like how to do that skillfully. She just comes in like, just like I picture her fingernails just coming to a point, just like everything about her sharp. It's not witty. It doesn't make a point. It's just nasty for no reason, to the point of being unprofessional. I mean, that's how I feel when I read her stuff. I'm just like cringing when I read it. And there's no like lovely little gotchas like what you find in Schuster and Friedman's. But yeah, so she was her typical self. And again, just there were so many things to be disgusted with in this mountain of motions that I will slowly work my way through. Hopefully, I get as much done over the weekend as I possibly can. But this one, when I do the pre-recorded, it takes me so many hours. You guys have no idea, unless you've ever had to make something like that before. There's so many steps. But so thanks for putting up with my sloppy lives, because I can do this. I just have to prepare the slides and then just give you my stammering self. So let's get started. So I chose to focus on this topic because this is one I feel like we started it when we asked about this subpoena way back 2 months ago, before anybody was talking about it. We were questioning, where did this subpoena come from? And it finally caught on and people started talking about it. And ultimately, Daily Mail released that they had seen this phantom subpoena. And spent the next couple of days talking to several YouTubers while they wrote their story. In the meantime, as we know, Without a Crystal Ball put out a video about finding the Van Zandt lawsuit. And then that kind of forced Daily Mail to hurry up and get their story out the very next day. And we found that that was, in fact, where this phantom subpoena had come from. So they filed this lawsuit on September 27th. Let me update this. Okay, yeah, this is the motion. This is the motion we're going to consider today. So this lawsuit was filed on September 27th, 2024, and then it was closed the day before Blake filed her CRD complaint. Like, that's not suspicious at all, which was, by the way, the day before the New York Times article came out. Again, not the least bit suspicious. Blake, you really fooled us. So one of the things that the Daily Mail, who seem to be the only people on earth who've actually laid eyes on this subpoena, they said there was no court stamp on it. And we are not the slightest bit surprised by that. And Blake stands everywhere. As soon as they found out about this lawsuit, they were defending it. Oh, it's okay because it's a company they own. They can do it. They made up every excuse. Even the attorneys that support her went out on a limb and were like, oh, no, they found a loophole. They found a workaround, like it was some clever thing. But it really isn't. And later I'm going to put a link. If you haven't watched the episode where I really tore into this, it's called Loophole Shenanigans, and I'm going to pin it in comments later. But it kind of goes through like the reason that the court has everything set up the way they do, because it's to protect everyone involved. They do not permit or allow you to just go in, do a one-sided Doe lawsuit, and get a subpoena to get whatever you want. It was done behind the court's back, not with the court's permission, and that's why there's no court stamp on it. So If you haven't seen that, be sure to go back and take a look because it lays out the whole process of how a Doe, there's actually two of them, two episodes back to back that show how a Doe lawsuit is supposed to go and what the actual New York law is about doing these kinds of cases. So let's see what Team Justin has to say about how this happened. Now, the first thing we're going to do is we're going to have a little Cassidy class. We're going to talk about some definitions here in this document. The first one you've probably all heard of, attorney-client privilege. So no doubt you know exactly what that means. But this means that communication between the lawyer and the client is protected. They don't have to disclose to anyone anything that's talked about in that communication. So there are some exceptions, though, and that's what we're going to focus on today. So there is, first of all, let's see. Sorry, I lost track. Hold on. Rattling my paper. I did this last night. I finished at 5 a.m. So I need to come back to it and talk about these a little. I think I got myself out of order here. Yeah, is it this one? Yeah, so even in here, it talks about there being some exceptions to the attorney-client privilege that warrant a disclosure of privileged information. So that means although almost everything that you talk with your attorney about is privileged, cannot force you to disclose this, but it is not absolute. There are times that it gets overridden. Now, one of the things that they talk about here is work product doctrine. So that's the next thing we're going to talk about. What exactly is work product doctrine? Because they're saying that this subpoena that was served to them is all about the Edgeworth Security Services. This is the company that got the information off of Jennifer Abel's phone. If you remember how that all went, and we're going to go through that. We've talked about it before, but we're going to go through it again in a little bit. But this is what I was talking about when I said that when you really serve a subpoena to get the information off of someone's phone, you don't send it to a person. It gets sent to a company that extracts information off of phones. So this is one of the other things I want to know about Blake's subpoena, because it sounds like she served it on Joan's work. So what I would like to know is, did Stephanie just give her the stuff that she herself had extracted from this phone? Or did that subpoena go and Edgeworth extract all over again and give an actual new bit of information that they actually extracted? And that's important because when you subpoena something, it has to be authenticated. It has to be verified. So that's the reason it has to go through a company like this Edgeworth Security that does this kind of extraction from phones. Then it's truly authenticated. You can present it to the court, say this was correctly gathered. But if you just got it from Stephanie, from the time that she extracted it to the time you handed it over, a million things could have happened to that evidence. There's no way to authenticate it anymore. I'm sure one of the first things she did was delete anything that implicated herself. You know, she didn't want to just hand that stuff over and say, oh, look what I did to Blake too, while I was still working on this case. So the chances of things being altered if she got it from Stephanie are kind of high. So that's one reason That will be important to find out. Did she get it from Stephanie, or did she just get it? Oh, thank you. Thank you very much. Let me show that. Thank you, Rihanna. So let me get back to this. All right. Now let's talk about the work product, because what they're saying about this subpoena that's for Edgeworth Security, is that what it's called? Let me get it right. Edgeworth Security, they're saying that it's protected by work product doctrine. Now, my longtime Murdaugh people that went through the whole conspiracy case with me, which by the way is developing again. I've been working on that. There's a new judge assigned to that case, Mark Tinsley and Tabor Vox. Mark Moore was trying to get them removed from the case, and he failed. The judge ruled that they get to stay in the case, but in that case, they tried to get things hidden by saying that it was work product. So my longtime Murdaugh people are already familiar with this, but if you're not familiar with it, it's very specific. It's materials that were created by your attorney to prepare for litigation. Now, even though that sounds really specific, when you go and start researching it, because I did back when I was working on the conspiracy case, it's one of those things that's so difficult to actually define, and it's kind of a case-by-case thing to try to sort out what actually qualifies as work product. If you look in the rules always have to do, this is why it's difficult to define. It's about mental impressions, conclusions, opinions, or legal theories. So this is the kind of stuff that's in someone's brain, and they can say, oh, this is part of my theory. You can't prove that it's not. They can't prove that it is unless they tell you their theory. So that's why it gets really, really tricky to try to define exactly what is work product and what isn't. So this is what they're saying, but it's kind of funny because we're talking about a situation between a company that extracts information off the phone and Jones Works. So it's not really, it doesn't really involve an attorney. So I don't know if they're going to be able to get that sorted, but this is all about protecting the sham lawsuit. Because we know that the reason that Blake got this information is because of the sham lawsuit. Now, it's different for Stephanie. It was a company-owned phone. However, what we saw recently in the newly updated complaint from Jennifer Abel to Jones Works, there were some federal charges now, and a state charge as well. So everything in this situation is being looked at under a new light. And this is what I found so exciting about this part. They were going to go a step further even than what we got to see with Jennifer's filing. We're going to go even a step further from that. And with the promise of more to come. So that sounds really, really exciting. So this is the part that really gets me. The absolute gall of them to say what they say in this first paragraph. So this is Stephanie trying to say that she doesn't have to turn this information over. And listen to how she says it. The subpoena requests seek documents that the Wayfarer parties in this case and the related case against Jones Work are required to seek from Jones Work as part of party discovery, not from Jones Work's third-party service provider. Subpoenas under Rule 45 are clearly not meant to provide an end run around the regular discovery process. Can you believe? She's talking about, the subpoenas aren't allowed to provide like a workaround. Never mind the fact that how how they did this information, this sham lawsuit, the whole thing was a workaround the regular discovery process. Forget that we did that. You're not allowed to do that. It's just a whole other big glaring hypocrisy. Again, they're trying to sort out to get to the bottom of a sham lawsuit that these people used as an end round around the regular discovery process and saying, "Oh, you can't do that. You can't do that. It's not allowed. This rule here says it's not allowed." So it's just absolutely so hypocritical. But let's see. And again, I highlighted this because the attorney-client privilege provides confidential communications between an attorney and client made for the purpose of seeking or conveying legal advice. What does this phone extraction and Jones works have to do with legal advice or anything to do with an attorney? So that she's just grasping at straws at this point because she knows she's in really big trouble. So now we're going to get to the third definition. This is one we don't hear of quite as often. It's called the crime fraud exception. So looking into that a little bit further, there's a case that's referred to La Liberté that dealt with this exception. And this was one that was in New York. So what it is if there is a factual basis for showing probable cause to believe that a fraud or a crime has been committed and that the communications in question were in furtherance of the fraud or crime. So this is what they're saying is happened. They're outright saying this is a crime, and so we can apply this crime fraud exception in order to have the subpoena enforced. This stuff is not privileged. This stuff is not protected if it can fall under this crime fraud exception. So that's what they're aiming to prove with this case. Now, what do they do to solve this sort of thing? This has been the big question of not knowing what's going to happen. We were kind of getting impatient. Why haven't they said anything about this sham lawsuit? They uncovered the sham lawsuit. But they had to wait. They can't just bring this to the court. It has to come in time, with each step as the case goes along correctly. So here is their first chance to address that, and address it they do. So what they usually do, and it's set up by this Supreme Court finding, United States versus Olin, they have an in-camera review. And again, those of you with the boat crash, the whole Murdaugh people that we talked about this last year, that's what they decided to do when they were trying to sort out, was that information actually work product that Parker was trying to claim was. So what they did is they had Team Parker, they dismissed Mallory Beach's family's attorneys, and they went through this with the judge piece by piece to review the evidence to determine what actually was work product, what was not. So that's called ex parte, when you only have one side there. The other side is not happy about being excluded, but it's done out of an abundance of caution in case it is found to be work product. And then the other team, they can't unsee what they saw. So it sort of has to be done that way, even though the other side does not like it to be done that way. So this is probably what they're going to do in this case, because it is the usual remedy. The judge would go through these documents first and determine whether or not he thinks they're privileged. And if he rules that they're not, then they will get a chance to look into that sham lawsuit. I can't imagine a judge looking at the sham lawsuit, though, and saying that it's protected. I really can't. But we haven't seen a whole lot from him about where he leans in his decisions. We don't have any of the motions to dismiss decided yet. So most of his rulings happened pretty early on in the case, and they were real basic things. So at this point, we really don't have an idea how he's going to rule. But that's the biggest thing that we're facing right now. Okay, so moving on with this. Oh, yeah, there's a case that's mentioned here, a John Doe case. And so I looked into this case. Now, this case involves an attorney, and he is John Doe. And it also involves a corporation, which is John Doe Incorporated. So in this lawsuit, they attempted to invoke the work product privilege in order to seal an affidavit from an FBI agent. So the judge did as usually done. He held an in-camera review and he ended up unsealing the affidavit because in that affidavit was proof that this attorney had tried to persuade the company to commit perjury. And so it qualified for this crime fraud because you're not protected if you tell your client to do something illegal. And so that's what they found in this case. Now this went further. The court decided that, I mean, he ruled on that, but let me go back to read this real quick. I read it last night. Okay, so what the court found was that the attorney had that this was the commission of a crime, and so this crime fraud exception was established. It granted the application for a stay pending appeal. So appellants came back claiming that their rights had been violated because they weren't allowed in the hearing. So I mentioned that a moment ago because of this. Often you have this ex parte, which is very, very rare because it's not fair for one side of counsel to hear something that the other side doesn't get to hear. But in this case, because of as I said, they can't unsee work product once they've seen it. So it kind of has to take place that way. So, but they said, oh, our rights were violated because we weren't allowed in there. But it was taken all the way to the Court of Appeals. And it was found that due process was not violated because the crime fraud exception strips the privilege from attorney-client communications that relate to client communications in furtherance of contemplated or ongoing criminal or fraudulent conduct. So that's why that particular case is here in this document because this was a case where it was found and this privilege was stripped away. So unlike the other side that just seems to put citations that have nothing to do with the actual document, when Brian Friedman and Mitchell Schuster put a citation in, it has everything to do with it. Next, we have the Richard Roe. Now, this case was a little different. It also dealt with work product. And there were 4 grand jury subpoenas that were seeking documents and testimony from the corporations and from the attorneys who jointly represented the firms. So there's 4 firms, 4 subpoenas, and then 1 attorney. So the government moved to compel production, saying that the matter sought fell within the crime fraud exception to the privileges. The district court concludes that there is factual basis to believe the exception applied. They conducted the in-camera inspection of the documents, and the court found that many of the documents did enjoy the privilege claim. But, let's see. It all comes down to, let me find where it comes. So they issued 2 orders compelling the production of the documents. They ordered that unspecified witnesses give virtually unlimited testimony concerning the documents, an investigation performed by the appellant's counsel, and opinions rendered by counsel during the time frame of the subpoena documents. Then, 2 of the officers refused to produce the subpoena documents they end up held in contempt, and they brought about an expedited appeal. What what the appeals court found, or the appellate court found, is that the district court had used an incorrect test to determine whether the crime fraud exception applied. And so they reversed and remanded. And that's what we're going to talk about is this type of test that's supposed, this standard that's supposed to be applied. So they reversed and remanded it back to court. Now, hold on. See, this is why I do pre-recorded. Let me find what I'm trying to say. So the reason that it was remanded is that the court determined that they'd used the wrong standard. And the standard that was supposed to be applied is what's called in the furtherance test. So that's what we learned from this case. That's the important part, why he cited this case, because this case is what shows you which standard that you're supposed to apply in order to figure out if this applies. So he goes on in the document saying that courts have long construed the exception as reaching some conduct beyond crime and fraud, such as intentional torts. So showing that it really gets spread a little bit broader than where it started, that it is applicable to torts like this one. And that particular case was actually one, I think I said international, I meant intentional torts. But that particular case actually was international. But it shows that this standard does get applied to intentional torts, not just criminal cases. Also, courts have applied the crime fraud exception where a party's actions in discovery are found to be calculated and purposeful litigation misconduct. In this case, I didn't put it on here, but I looked it up, and it has to do with some medical diabetes test strips. But, and it's a really long case, so for the sake of time, I didn't put that one on here. But what that case brings to this case is that it applies when there's calculated and purposeful litigation misconduct. And that's what they're saying happened with this sham lawsuit, that there was calculated and purposeful litigation, even as far as the dates. Like they weren't even careful about trying to hide the dates to try to make it look legit. You know, it was very calculated, it appears to be. So, sorry guys, I need to take a drink. I'm going to mute for a second. All right, sorry about that, guys. So this is where I said we would get back to what happened to Jennifer, how her phone was taken, and we covered this in earlier episodes. But if you missed out that, and just it's so egregious, I'm just going to talk about it again. So August 21st, and this was 2 days before what was supposed to be Jennifer Abel's last day. If she had those extra 2 days, she could have securely taken care of her phone. So I think this is the beginning of showing calculation, because they corner her 2 days before her last day. She wasn't expecting it. You know, if this had happened on her very last day, she might have been a little more prepared to have something awful happen. But they struck early and caught her off guard. So to me, this is like the first calculated move, because not only did they do it 2 days before, you don't arrange something like this right on the spot. She had a whole team there poised and ready. That takes some planning, some preparation. There were attorneys, there was this Edgeworth right then and there at that very moment. There was a huge security guard. She described him as large and imposing. He's outside the door. So she comes in surrounded by attorneys. They completely intimidate her. They pressure her. They threaten her. They have her hand over her laptop that was her personal laptop. That didn't even belong to the company. But they did it by accusing her of stealing something from the company. And so they do the forensic. Who knows what they grabbed off of it? They could have grabbed all the contents of her personal laptop as well. We don't know. But they do a whole forensic of her laptop under the guise that they believe she stole something that belonged to the company. They find nothing. So they do it again. And then they take her phone, and she wanted her phone number because although the phone belonged to Jones Works, it was her personal phone number that she'd had since high school that she had applied to that phone. So that phone number needed to be released from that phone in order for her to get it and move it to her next phone. So they say that they're taking it so that they can do that. But that's not what they do. Because she goes straight from there to Verizon to have it applied to a new phone, and it never happens. She waits there for 4 hours, and they stop answering any texts, any phone calls. They're just completely ignoring her because instead what they're doing is taking everything from her phone. Now, even if this belonged to Jones Works, there are a lot of things that they had no business accessing, such as her iCloud, such as her email, her third-party apps, her personal photos, all of these things, but they go through and take absolutely everything off of her phone. And as we found in the last filing, Stephanie continued to access her iCloud because Jennifer was not aware. She thought when she signed her number into her new phone that they could no longer access it on her old phone. But all of that time, not only did Stephanie have everything she took off the phone that day, but she continued to access, and that covered all kinds of privileged information. She was accessing it all the way up to January of this year, after having taken it in August. And so that's where the federal and state actual criminal charges come into play. So then we also know that on August 21st, that's when Leslie Sloan contacts Melissa Nathan and tells her, "We're going to sue you. I've seen the text messages." So while Jennifer's there at Verizon waiting for her phone number to be returned to her, and Stephanie has no time for that, she's downloading all of this and sending it to Leslie Sloan, to Blake. Forget the fact she's still under contract with Wayfarer and Jennifer Abel, breaking all kinds of rules and laws just out of spite because she's angry, allegedly. So that's how they accessed all of her things in the first place. Now, we already know, and she's had to admit, that she possesses her private communications, that they were forensically extracted. And this is the part I was talking about. We saw this in Jennifer Abel's her later filings, her last two, with her when she brings Jones Works officially in as a third party and files a complaint against her. So we saw these were all new charges in addition to the regular civil causes of action that we'd already seen since the beginning. These in purple were all added. Now the thing about these, and if you didn't see that episode, I'll repeat it. So these are all criminal offenses. The first 1, 2, 3. The first 3 are actual federal offenses. This means you can do prison time. This means huge fines. And then the 4th one is a California state law violation. So, still a criminal act that you can do prison time for, along with fines. So, how does that work? Does that mean all of a sudden criminal charges get admitted to this lawsuit? No. It means if the law gets involved in this, the federal crimes will be covered by the US attorney, possibly investigated by FBI. The state, if they want to pursue it, it would be taken up by the district attorney and would be investigated in that route. So that would mean 2 additional actual criminal trials. So they won't blend in with this. This will stay a civil trial. These are added as civil complaints, even though they are actual crimes. They're added here for the civil part. In this part, it will only result in damages that Jennifer Abel endured because of these actions. But if the authorities look at this and say these are actual crimes, we're going to pursue this, then in fact, she will be facing possible prison. And this would be 2 different prisons. My Murdaugh people know this too, because we went through this with Alex Murdaugh and with his accomplices, Russell Lafitte and Corey Fleming. They got their federal charges first, which is what you want to do, because if you're going to serve time, you'd rather serve it in federal prison than you would state prison. But if you end up with consecutive sentences, or if the state is longer than the federal, you could end up doing time in both, which would be, I just want to ask her, was it worth it? Really, was it worth it to do all of this? Did you get your money's worth? Just to be able to do this, to get your little revenge. Now you're facing possible criminal charges. So this is where it gets very serious. Now they talk about, on the same day, I mentioned this just a minute ago, on the very same day she gets this information, first thing she does is discloses it to, we don't know if she spoke to Blake directly or if she spoke to her agents. But this is where Ezra needs to take lessons, because her shrill claws, fangs is so unappealing. But look at this. Like, this is beautiful. I always giggle the first time I read through these documents. At the time, Lively was reeling from a storm of self-induced negative publicity surrounding It Ends With Us. And she saw an opportunity to use the ill-gotten communications to spin a false tale of a smear campaign to the New York Times by cherry-picking and splicing communications, which, when viewed in full context, demonstrate an effort to prevent Lively's vicious behavior and malignant persona from overshadowing the film. Because Jones Works had illegally obtained Miss Abel's communications and then improperly disclosed them to Lively, Lively needed a veneer of legitimacy to explain her possession of the stolen materials prior to giving them to the Times. So, this is what happened. They describe Blake, and I love it. She's reeling from the storm of self-induced negative publicity. So, this is what happened. She had always been surrounded, and I've talked about this before, surrounded by her fans, the people that grew up watching her in Gossip Girl, the people that idolized her, wanted to be her, the ones, appearing on every post of hers, to like it and tell her how much they love her, and all that fangirl behavior. She's been used to this for years, right? Oh, sorry, my phone's getting messages. Move that. But what happened is, with this movie came a whole different crowd of people. And we talked about this before with, like, the different generations. Blake's a millennial, that's where most of our fans are, and now you have Gen Z. They didn't grow up with Gossip Girl. They might know her mostly as Ryan's wife, don't really know anything about her. But Colleen Hoover's books are really, really popular. This one in particular, this has been off and on the bestsellers list repeatedly. It keeps coming back. I mean, it's sold so many. Then on TikTok, there's what they call Book Talk, where it was one of the biggest books on there with like a billion hashtags. So this book was huge, and Colleen Hoover's books are written for the young adult genre. So it's young people. They they're a different generation, and they love to call things out. I went through this. There's actually been studies done about the communications of each generation. We all have our type in our generation of what we do. Gen Z, they're the ones that were born into the digital world. It's always been there. It's all they've known. They're on their phones all day, all night, and they're used to being able to voice their opinions. So these are not people that have been Blake Lively fans. These are people who are fans of the book. These are young people. They knew that Lily Bloom was supposed to be, 23 years old, something like that, early 20s. So the first thing they see is Blake in these horrible clothes. And I'm not gonna lie, you know what? I had this I had this like meme pop into my head the other day because I was going through something where it talked about how Blake had added so much more to the budget of the clothes because the clothes had actually been purchased before she came on. So the budget had already been spent. And then she decides it's not the clothes that she wants. She's got a better idea. And so she literally goes home and raids her closet, and not just her closet, her husband's closet, and they bring their clothes. And when I first heard this, because I know nothing about showbiz, when I first heard this story, I thought she was doing Justin a favor. I thought she's like, "Oh no, it's okay. I'll bring my own clothes. You don't have to buy more." Little did I know, she's charging him for the clothes that she brought from home, but it cost her nothing to do, but they have to, like, rent these horrible clothes, to wear in the movie. They're paying for this, and who knows, she may have even gone out and bought that stuff, being like, "Well, I'll get reimbursed for this, I'll get a whole new wardrobe out of this." Who knows what her thoughts were, but, it just popped into my head the other day. I'm like, that's why she wore, like, 2 pairs of pants and 6 shirts because she's going through her closet going, "Oh, I can add this, and I can add this, and I can add this and get even more money," And I'm just like, I just wanted to make a meme of her doing that, going through and, like, that's why she layered all these clothes and brought every coat she owns and all of her ugly boots. It's like, "Oh, more money, more money, more money." But anyway, that's just where my crazy head goes. But that was everybody's first impression. So if you're a young kid, if you're like in your late teens or early 20s, which are the people who loved this book, that's their genre. And then you see a woman that's closer to your mom's age, just coming off of having her fourth kid, and she's wearing these things. You're going to be a little shocked. You know, you just are. That's young people have no we were all young. We know what it's like to be in your teens and you look at people and you're like, "What?" And you have, no sense of decorum yet. And what's the first thing you do if you're of the digital generation? You talk about it. And you don't talk to people, you talk on the internet, you talk on social media. So that's what happened. And then it just got worse and worse after that. The people who were attracted to this book were people who were into this story. And what is this story? The story is all about domestic violence. They came for this story. Besides of the young people attracted to this, we know, like my longtime Murda people, we've talked so much about the abuse that women go through, the statistics that in this country, 3 of us every day are killed by our partner or our ex-partner every day. If you put the whole world into this, it jumps to 10. So, we have people and that's just the murders. That's not the abuse. A lot of people, most people who are going to be abused and not murdered. But if there's that many that come to the point of actual murder, just imagine the numbers of the abuse. And unfortunately, we'll never know that true number because most victims hide the abuse. So we're talking about a very serious situation. We're talking about most of us know someone who has endured some sort of this, if we didn't see it for ourselves or endure it ourselves. So it's a topic that people feel really strongly about. And it's a topic that honestly doesn't get highlighted enough. So when finally a book comes out that's supposed to deal with it, people were championing it and wanted to see that. But that's not what they got. When Blake started promoting this movie, she wouldn't even mention it. And they try to put this on Wayfair and say, "Well, Wayfair said blah 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 blah." And so many they keep putting, the I forgot what that sheet was called. Again, not familiar with show business stuff, but it was like the marketing plan, I guess it was, um, of how they were going to do it. They twist the words to make it like it was absolutely forbidden. That wasn't the case. They didn't want it to be dark, but they specifically said words like they wanted to show hope and they wanted to show, oh, now I forgot the word. It's not courage. I think it had something to do with like, getting out of the situation. I can't remember exactly what it said. I don't want to say it wrong, but I think you guys have all seen the picture. But in order to have those things, like if you need hope, it's because there's something that you need to get out of. There's something bad you're going through. I mean, in order to hope for something better or hope for something to change, you have to be in a situation that's bad. So how do you address strength? That was the word. Hope and strength. How do you address those things without addressing why you need them? It was never saying just talk about flowers and just talk about cookies. That was not the thing. And there should have, even if you're there and you don't want to go out there and just, oh, let's talk about beating. You don't want to do that either, but you do want to have somewhere a website for people to go to, maybe pamphlets, and there's nothing wrong with the little pop-up flower things that they did. Those were so cute. But you have to have, like Justin had tied in, like well before marketing, he had tied in the No More organization. Having just that listed so people know where to go for help. Having little pamphlets, just something somewhere on the booth. Do your fun stuff, do your flower stuff, but have something to address this because you don't know who might be coming there that needs help. And there was nothing, and there wasn't just nothing, the attitude behind it, like when someone dared to bring it up to her, the way she was sarcastic and rude about it. So, like I said, these people wanted this topic specifically addressed. That's what attracted them to this story. It's what they wanted to hear about, but if they brought it up, they got sarcasm and rudeness. Then, in that little miniature, I've shown it several times, There's a little miniature flower shop from the movie. What's inside? Her liquor. There's miniatures of her Betty Boos and Betty Buzz. You know, that was just that's not the place, because as it said that a lot of domestic violence comes from drunk, the guy gets drunk and beats his wife, or the woman gets drunk and beats her husband. So, it kinda has like a and women who've gone through that, they kind of equate alcohol with that. So it's you don't want to put something in your marketing that's going to trigger the people that you're trying to attract. So yes, everything that she did for marketing was so tone deaf. And then I've showed you that first just clips, and last time we went through the whole thing, but that little marketing stunt that Ryan put together that included Hugh Jackman, that involved real sexual harassment, worse than what Blake alleges happened to her, is in this. There was not one thing related to the film that was in that little marketing video, and it's absolutely insane. Also, we had her on her Instagram, and I've gone through her Instagram and taken pictures of, and she still kept it up. You'd think that she would have come to some sort of realization and taken those down, but last I saw, they're still there. It's her posing in, just designer clothes after designer clothes that have a floral pattern standing in her, I think it's her house, I don't know. And then she lists, she's wearing Chanel this or, whatever. And it's like, what does that have to do with the film? Just because you're wearing florals, So there was all of that. And then there was her hair care brand and more advertisements for her beverages. So again, we're not talking about her longtime adoring fans who everything she does is wonderful. We're talking about this new generation that probably heard about her really for the first time with this, because she hasn't really done much with this was her first movie in quite a while. And the last movies that she had done, like back in 2016, they weren't really so much for a younger crowd. We had like Age of Adeline was 2014. But yeah, they were more adult sort of movies. So she hadn't really put anything out for the younger generation to even know her. So this was their introduction to her, really. Seeing her in these clothes, playing their beloved character that's not what they envisioned. And then all of this bad tone deaf marketing, the flippant way that she spoke in all of her the interviews around the movie. She's very off-putting, to me. I mean, her fans seem to like it, but I feel like it's sarcastic. I feel like it's rude, self-centered. She says a lot of words that don't really mean much, and so when you're expecting this specific message to be delivered in your film, and then it's not, and then you go to talk about it like this generation does, this is what you get. So was it a smear campaign? Because here's the other thing they mentioned, and this is something I've said before too, that let me find it. Let's see. Yes, demonstrate an effort to prevent her vicious behavior and malignant persona from overshadowing the film. So she's out there, and it's bringing all this bad press. How does Justin react to this when it happens? They try to shut it down. Jamie sends him an email, change the marketing. It's not going over well. They want this movie to succeed. They weren't happy about this bad press right around the time of the release of their movie. They wanted this movie to be a success. They'd worked on this movie for 5 years. The last thing they wanted was negative publicity around the film, because that was going to affect them too. They had done kind of smaller movies. This was going to be their first really big movie. They wanted it to succeed. They didn't want this smear campaign. They were prepared. They were preparing a defense in case Blake did something. This smear campaign didn't exist, and as they've said in other documents, Stephanie Jones knew better than anyone because she was their PR person when this was all going down. She knew firsthand, and even after she was no longer the PR person, she still had access to Jennifer Abel's phone, and she was in fact still accessing it, and this is so easy to prove because every little thing you do electronically leaves a trace. So she got caught red-handed with that. So she had access to all this. She knew it wasn't true, but she was angry and she wanted revenge. So she took this information straight to Blake. So then what happens? They have this information. Now Blake's blaming angry. She wants to do something about it. She's like, there's this smear campaign against me. I want to sue. But here's the problem. I'm not supposed to have this information. So what do? I got to find a way to claim that I got it legally. So on September 27th, this sham lawsuit comes into play. And we know this. We've been through this. It's been all over everywhere. And I want to say at this point, when this lawsuit got revealed and people started looking into Van Zandt and the shell company and then started investigating, well, what other companies do they have? What have they done with these other companies? Have they done other things like this before? I think that triggered something for Blake and Ryan, because that's when we started seeing them getting back out in the public. That's when they bought their little top 100 times, most influential people. That's when she started making appearances again. Ryan started getting out there more again. And guess what else started happening? Those of you who are here on YouTube or TikTok, it hasn't happened on YouTube so far, but anyone who talked about Van Zandt, this sham lawsuit on TikTok, was getting those videos literally silenced. Thank you, Fred74. What was the timing of Ryan's letter to where? Oh, Ryan's letter to Wayfair. I can't remember the date. But I'll thank you very much. And I will let me star that and get back to that at the end of this. And maybe in the meantime, we can find that date of when that was. But yeah, it all goes along. The timing of everything, when you look at a timeline of this, it's all so calculated. It appears to be so calculated. But what I was saying is, so these characters on TikTok, when they talked about this sham lawsuit, their videos weren't taken down, but the audio was stripped. So it's just them sitting there moving their mouth. Unless you're a lip reader, you have no idea what's being said. And it's just so funny because all of them, I don't know if you guys have seen this, but there's an attorney, not actually Golden, that I just love. I want her, not actually Golden, please come more on YouTube. I want her on YouTube because I think you're safer here. But what they used is copyright striking. And this is a method that I've come to find out it can be used in many ways. It happened to me, not about this case. It happened to me where someone used a false copyright strike. Most of these mediums, they don't want to mess around with the copyright claim. So they don't investigate it very well. They receive the message and they just want to get rid of it because they don't want it on their platform. So it works really effectively to take something down, to get rid of it. So unless you can fight it, that's just it. But it turns out on TikTok, there's no way to fight it. So, oh, My neighbor loves his lawn. I'm so sorry. He's out here all the time. I don't know what he's doing now, but it's pretty constant. So sorry about the sound. This is the stuff I usually edit out when I pre-record, but we're gonna have to just work our way through it. Sorry about the sound. But so TikTok has absolutely no way to fight it. So these people's and it's just their voice. There's no background music. There's absolutely nothing that anybody could legitimately copyright strike. But they did. And get off my lawn. Yeah. But so anyway, so that's what's happening to content creators. And I shared a little bit about what someone had sent to me last week from Reddit, where someone was asking about me, wanting to know where I am. And, and what do they want to know that for? They want to try to find me, right? And and it turned out when that person fought with them on Reddit, if you didn't see that particular live, when that person fought with them, they started getting all kinds of screenshots from other people, some of them lawyers that have been questioned by this person as well, because she's trying to find out who everybody is, which I think is very suspicious. Is she collecting information for these people? Because she claims to be a lawyer, but she like lives on Reddit apparently, not just on this case, but some other reality TV and stuff. So it's very strange what's happening, not just to the PR people and Justin and Steve Sarowitz, but it feels like a lot of the content creators, after this sham lawsuit got discovered and we started talking about it. Yes, we're talking about Kat Ortega on Reddit, who claims to be a lawyer but doesn't show her own credentials, but thinks everybody else needs to as well. So, or that everybody else needs to, just not her. So, of course, she's a Blake fan because it's rules for thee, not for me situation. So, yeah, all of this after the sham lawsuit was found, that's when Blake and Ryan started making more public appearances, and that's when things like arson started happening and being threatened. Kirsty Fla, I know I said her name wrong. Sorry. I'm a big fan, but I think you all know who she is. She's the famous interviewer that Blake insulted by congratulating her on her little bump when she wasn't pregnant. But she's named in the lawsuit, actually. She's in the documents that came out yesterday. They're looking for any communication between her and the PR teams to see if they put her up to what she does on her channel. I mean, that's how bad it's getting. But she was threatened with arson as well. So it's just crazy that once the sham lawsuit came out, we started seeing so many things start happening. But because it actually brings up a possibility of criminal charges. So that's what happened with this lawsuit on September 27th. It was a transparent ploy, and they included in Exhibit A, I think we've all seen it, a transparent ploy to manufacture a procedural vehicle by which Lively could subpoena Jones Works for Miss Abel's communications. And here we have in italics, without notifying any of the Wayfarer parties. So that was a big thing. So what they did is they filed this, and we're going to talk about this CPLR 3120. So this is a specific law or a rule that permits the service of a subpoena merely upon commencement of an action, unlike the federal rules of civil procedure. But in the one that I go over this loophole, we go through the way that the court has set up specifically a Doe lawsuit. So you can't just say, well, I'm going to apply this CPLR 3120 to my lawsuit, and this just gives me permission to just issue the subpoena with nothing. You can't just like call it like you can call shotgun. I call CPLR 3120. You can't. So And that really I don't wanna get into all of that, but if you I will link that one so you guys can go through and see why they couldn't just simply do that. If you could simply do that, why would the court have put up all of these rules that have to be followed? If you could just simply do that. So what I've always held to is they didn't do this with court permission. They did this behind the court's back. And so and here's where we bring in Ryan Reynolds. This could have just implicated Blake, except for she chose this particular business that's registered in both of their names. So now it brings them both into possibly facing some consequences for doing this, and also their law firm, which is the law firm that still represents them. It's a different attorney. The attorney who did this, Samantha Katz, she's no longer representing them in this lawsuit. I don't know if she was the sacrificial lamb or how she ended up being the one that had to do this. But I think they thought no one was ever going to find it. So, Rule 3120 is about discovery. And when you look at this, if you read just part 1, it says after commencement of an action, any party can serve this particular type of subpoena, which is a request for documents. So this is what they're trying to hide behind, right? But when you have this rule, you have to take it completely. You can't just take that first line and pretend that it covers you. Because as they mention here, the rest of 3120, but it goes on to say that, let's see, they should have been served. What it would have required is for them to have been served a copy of the sham subpoena. And I love how he just straight up just calls it a sham every time. Just sham, sham, sham. Not just once, like every time he says it, he puts the word sham. So when a subpoena is issued, the other person is supposed to have notice, because they should have a right that if it's overly broad or asking for something that's privileged, they are supposed to have a chance to say that to the court. This is overly broad. Quash it. Reissue another one or limit this part of it. This is privileged information. You can't have this. But because nobody was notified, nobody got the chance. And so this subpoena, going all the way back to 2022 and covering absolutely everything, instead of the usual subpoenas that are very restricted to what content they can get. Certainly, no subpoena would have allowed access to her photos and her personal emails and her third-party apps. But since no one was minding the store, that's what this subpoena got for them. Hold on, I need to drink again. Sorry about that. My mouth's getting dry. So then Jones Works didn't object because they knew it was coming. They'd already given Blake the information. This was all just a sham to try to legalize it. So, of course, she was ready there and waiting. Waiting, I just got all proper. Ready and waiting to just give this stuff to them. So, and this was wrong on her part as well, because she had obligations with contracts with these people. She had no right to just hand it over, but she did this to protect herself as well, to say, well, it was a subpoena. I had to give it to them. And I love the way they said, see his words. I just love the way he speaks. Blithely surrendered the entire contents of Miss Abel's stored communications a second time to Lively. And again, I really want to know, was it an actual grab of the phone again, or did Stephanie provide what she thought fit to provide? So, and then they say again, tellingly, that December 19th, that's when they discontinued it. This is the day before the CRD complaint was filed and 2 days before the New York Times article came out. So, look what we see here. Despite repeated demands, Lively's counsel has failed to provide the Wayfair parties with the sham subpoena. And I thought that was such a rich point because this pile of motions to compel that I went through last night, we're just fussing and fussing and fussing at Wayfair. Oh, you're weeks past the deadline. We need the court to compel you to turn this discovery in when this, the most important item that's needed right now before things can proceed is this subpoena. So they're sitting there holding that and saying, you give us, we're demanding, and we want the court to demand that you give us this stuff right now. So again, the hypocrisy is just so astounding. But getting back to this Rule 3120, there are other parts besides the first sentence. For example, 3, this is what they had in parentheses in the previous slide, that the party issuing this subpoena shall at the time serve a copy of the subpoena upon all other parties, and then give each party notice that the items produced in response thereto are available for inspection and copying, specifying the time and place thereof. So even if they want to try and say, oh, well, 3120 means I can do this immediately after filing an action, it's okay. It's still not okay because they skipped this part, that they have to provide notice so that the others have time, like we said, to quash it, to file a motion to quash if there's something wrong in it, if it's overbroad or privileged. The other, I mean, and just like look at 4. Look at 4. Now, this doesn't apply to this particular case, but the reason I want to mention it is because it says nothing contained in this section shall be construed to change the requirement. And it's talking about if you're serving a subpoena on some kind of government company, like a library or a Bureau of Municipal Correction. So just like you can't take number 4, you can't ignore number 4. If you're serving a subpoena to a library, you can't just say, well, I'm applying 3120, so I don't have to do this. You can't ignore that. So why do you think you can ignore 3? You can't. You have to follow every bit of this rule. You can't just pick the first sentence and say I'm covered because I filed an action. Because it's also a Doe lawsuit, and a Doe lawsuit has its own rules that in order to get a subpoena, since you're not quite sure who you're getting it from, because a real Doe lawsuit, you don't actually know. And I showed examples of that. It was like you have an IP address of someone that's harassing you or someone who somehow got into your, I think the one example, they got into their LAN network at their place of business. So they had a forensic team actually get the IP address. They don't know who the person is. That's a legitimate Doe lawsuit where you really don't know who it is. You only have the IP address. So you need to serve a subpoena to the phone company to divulge that information to you. But because you don't know who it is, and you are supposed to provide notice to the other side, you have to appear before a judge and prove that you have a prima facie. You have to meet that standard, that you have cause for this. The judge decides whether or not, and if he finds that you do, he grants the subpoena. So there are so many things in place to protect the other side. You have to be fair in a court of law. So them trying to hide behind 3120, in my personal opinion, I don't think it's going to work. Or it shouldn't work, at least. Okay. All right. And here we have more witty spice. We have, and And way back, when we were still trying to sort out where this subpoena and this sham lawsuit came from, we talked about this, that, how it was worded in Blake's complaints and also in Jones' works, it was tricky. They would say through legal process, including a civil subpoena. So if you just did a legitimate subpoena, it would just say, "We subpoena this information," right? So I always felt like this wording was very strange, and the wording changed each time. It started with the CRD complaint, and then in her original lawsuit complaint, and then her amended complaint. Each time, the wording changed a little bit to where her ultimate amended complaint said something like that she believed it to be legal throughout the whole process. Do you guys remember that? It was really weird the last time. It was like they're pulling back a little bit each time, like, uh-oh, we might have gotten ourselves in a little bit of trouble here. But when it says legal process, including a civil subpoena, that word including, I mentioned that like way back, like 2 months ago. Like, what does this mean? Because when you say that, it means there were other methods that you used. So what are they? But he's talking about this that appears in both Blake's and Jones' works complaints. But then he mentions how the subpoena, the sham, again, he never says this word without saying sham subpoena, sham lawsuit, sham this, was issued in a case where Lively intentionally omitted herself as the plaintiff to avoid publicity, and intentionally failed to name the Wayfarer parties as defendants or any actual defendants to avoid the obligation to notify them of the sham subpoena. And they also mentioned something, we all said too, as soon as we saw the sham lawsuit, that she had no intention of actually litigating the claims in the sham action. She didn't even have a right to. Nothing happened to that company. And let's see, Jones were publicly claimed. Yeah, equally as bad. Jones works, so he's implicating both sides, but this is the first time it's implicating Blake as well. So this was a big deal because it's finally getting to be addressed in the court. He finally had a means to do it. So because he didn't move to he didn't file to for leave to amend his complaint another time. So we wondered, like, how is he going to address this to the court, to bring this to the court's attention? And this is it. This is how he chose to do it. And this is the first time he implicated Blake directly. Last time it was specifically just about Jones' works in Jennifer's counterclaim. But now we see he's specifically saying Lively did this. Lively did this. So this is coming to the court. So this is what's going to make Judge Lyman have to address this issue. So this, of all of these motions that were filed, this is the biggest one because this is the one that's saying, hey, Judge, this is what happened. And this is what Judge Lyman will have to rule about. So it's unclear how the sham subpoena could be court ordered, given that no judge was assigned to the sham action, which would have required the filing of a request for judicial intervention. And this is why I say this was done behind the court's back, not with the court's approval. There was never a request. There was never a judge assigned to this case. There were two filings, the initial one and then the withdrawal of it. There was never, the court never did a thing but accept these documents to be filed. So this is going to be very, very interesting. And the reason, I keep going back to the loophole shenanigans episode that I did. Judge Lyman probably in his career as a judge has had to rule on a Doe lawsuit at one point. And even if he hasn't had to actually rule on it, he knows what the rules are, and if he doesn't recall them clearly, he just has to go look at them. So he is not going to be one bit fooled, no matter how these people call it a loophole or a workaround or clever lawyering. Judge Lyman knows how this is supposed to go. He's not going to be fooled because you tell him, oh, it's a clever workaround, it's a loophole. So I just hope, I really hope this goes to a hearing and that he lets us listen in like he did last time, because this is going to be fun. Sorry, I'm going to mute for a drink real quick. Okay. And this part's fun too. As the Wayfarer parties prepare to seek further relief with respect to the sham action and sham subpoena. So they're not done yet. They're just getting started. All they need is for Judge Lyman to address this and rule on something here. And then I bet there's a whole lot. But first, they need to actually get the subpoena before they can do a lot of things. Thank you so much, Ellen. Thank you for the thorough research analysis and breaking down. Oh, thank you. Thank you, Ellen. Yeah, I get very emotionally involved in these things. I can't stand bullying. I hate to see corrupt power. You know, it's why I was so attracted to the Murdoch case. When you have these people with nearly unlimited power, and like people so aptly called it a David and Goliath. But in this case, there's a bunch of Goliaths. There's so many of different sizes and strengths. It's not just one on one. And then we also have, and the women don't get mentioned enough, and I get so sick of Team Blake pretending, and I'm going to be rude here for a minute, but their self-righteous attitude to pretend to be doing this for the sake of women. Get over yourself. How many women are you trampling on to protect the movie star that you adore? You're not doing this for women. You're doing this for Blake Lively. Blake Lively, the spoiled millionaire, married to a multimillionaire on his way to becoming a billionaire. She doesn't need your help. Blake Lively, who wouldn't toss you a crumb if she heard you were hungry. Blake Lively, who, if you approached her in the street, she'd probably have her bodyguard escort you away. And these people are devoting like 20 hours a day coming out trying to defend this woman who doesn't need your help. If you have that much time to spend and you want to help somebody, do you know how bad women's shelters are right now? There are women out there who don't have millions, who don't have millionaire husbands, who don't have bodyguards to protect them, who are actually getting raped by their partners or ex-partners, who are actually getting beaten, and they've got nowhere to go and no one to help them. And the women's shelters are so limited. They can only take you in for so much time. They can only provide so much protection, and then you're right back out there. And this is happening every day, everywhere. Those are the people. If you really want to champion women, get your butt out there and do something for the women who need you, not this spoiled princess millionaire with a millionaire husband. If you've got 20 hours to spend on social media, yeah, yes, God forbid you have kids, and most of them do, because abusive men like to keep their women pregnant and at home with kids. If you've got all these hours to devote to being here on social media, helping Blake, you've got time, go get a part-time job and use all of what you make there to help a women's shelter. Why are you working for free? Why are you working for free for this millionaire who doesn't know you, doesn't care about you, and claiming that you're doing it for women? Because you're not. I messed up my Okay, what'd I do? There we go. Messed up my screen when I started typing crazy. But they never think about the other women that they're affecting. Jennifer Abel, she doesn't have millions. She doesn't have a bodyguard. She's just a woman out there getting death threats. Melissa Nathan, she's just a woman. She's just a woman. She doesn't have, Justin Baldoni had to take his family to Hawaii to escape these crazies. And what about their wives and their children? I've said this so many times. To be their wives, to be humiliated like this woman telling the world that your husband just couldn't help himself. He was just sitting there waiting to get a peek at Blake Lively's boobies. Just waiting out the trailer, just hoping when they walked in she was going to be breastfeeding. It's sick. What about those women? These people that are saying that they're doing this for women and calling us misogynists because we're on the side of truth. It's crazy. They're doing nothing to actually help real women who need their help. So get over yourselves, people. Stop lying to yourselves and admit that you're like a 13-year-old who's got a poster of a movie star on their wall that they kiss every day. Because that's what you're doing. You're not helping anybody. Anyway, get off my high horse now. So, in my opinion, let's see, where were we? So he talks about this tortious conduct and a violation of multiple federal and state statutes. And we just went over those. Federal and state. These people are facing actual criminal charges by this type of misconduct. And what is serious litigation malfeasance? It's misconduct, but it's misconduct specific to legal proceedings, and it's deliberate and it's harmful, and it goes beyond something like negligence. Like, this is more in terms of like calculated stuff. It's not just negligence or error. And it's this kind of deliberate harmful conduct that's meant to gain an unfair advantage. So it couldn't describe what they did better, I think. I think this is a perfect description of what they did. They did it to get an unfair advantage, and it was deliberate, and it was harmful. It was a sham lawsuit. And so they say the court should find that the crime fraud exception applies to Jones Works' claim of privilege. And then we get the biggest statement of all. Is that they seek further relief. So, what does this mean for Blake and Ryan? They haven't said. He hasn't said yet. I believe that's coming, but first, this all has to be established. So, right now, they have Jones Works, but this is the first time that he's actually mentioned Blake and actually mentioned Ryan. And if they were holding this, all of the contents of Jennifer Abel's phone, there's a possibility that, if they know that it was gotten in a bad way, if they could become party to these criminal acts. Now, I'm not going to say that that's what's going to happen. I'm saying it's a possibility. We have to wait and see where this goes, how it's decided, how it's presented to the court by Justin's team, and then again how the judge reacts to that. But I think this coming up against Stephanie first will establish, I think it's like a test. And you do have to prove, because Stephanie's the one who actually handed the stuff over. She's the one who told Blake about it. But it's Blake who brought the lawsuit, and the company that she used implicates Ryan as well because it's in both of their names. I wonder if he knew she did that. Or if it was his idea. Whose idea was it? I wonder. I can't wait to find out about that. But let me look at my closing, what I had. So again, yeah, the reason for this particular thumbnail was this, that they're trying to shut up social media. They've got mainstream media pretty much bought. They're not reporting, hardly anything reports anything negative about them. It's all like sunshine and flowers. So there's a whole group of people that are not getting this news. You're only getting all this behind the scenes of what's really happening on social media. And it's kind of sad, and that really needs to change. I'm hoping when this gets ruled on, if the judge does rule this is a sham lawsuit, this is bad, and it does go to criminal charges, I would think finally the mainstream media is going to have to report on it. But as of now, it's just us here on social media, and they're trying to shut us up. They honestly are, whether it's trying to find out who we are to dox us, or literally silencing these videos. They're trying to shut us up, and it's sad, and it needs to be stopped. Because they're claiming that she that's the whole thing. She's trying to claim she was being shut up. But in fact, they're doing exactly, what? Pointing fingers. Yeah, I should have I should have made them a mirror of them pointing at each other, right? Put them on each side, like reflecting, pointing at each other, because that's what they did. That's what they did. But okay, so anyway, that's the conclusion of this one. There is a whole mountain of other motions to get through. Some of them make me so mad because, again, they bring in Justin's mental health, which is so very wrong. And I'm sorry, when you are this high of a law firm, this law firm is humongous. The amount of attorneys they have, the level of, if you were put all the years together of all the experience of these attorneys, they know how to redact a document. But do they? Nope. They've put out these people's addresses. Like I said, Jed Wallace's health condition, now Ryan's. These same hypocrites who sat there, Ezra screaming her shrill voice, demanding this attorney's eyes only designation, in addition to the regular methods of privacy that are accorded most people in court. They get these extra protections because they're celebrities, and their witnesses are going to be celebrities, so they get this, and then they turn around and don't redact a simple document and put it out there. And I'm sorry, but I cannot imagine a world in which that wasn't intentional. You're this big of a law firm, you're supposedly the best, and you can't redact a simple document. It's insanity to me. It doesn't make sense, and I just can't accept that it wasn't intentional, you know? I mean, when you hire the likes of an ex-CIA guy, it's no holds barred at that point. You're kinda letting the world know you're gonna use beyond the regular methods, to do whatever you have to do, and I should get off before I say too much because I'm starting to get too mad. I don't wanna get myself in trouble here. But anyway, thanks everyone for joining. Did you have any questions besides Blake's herpes? Because I don't wanna talk about that. I don't wanna talk about that. Any questions now that that's finished? And again, if you weren't here at the beginning, I let you guys know, while I'm talking, I don't wanna look at the chat too much because it gets distracting, and then I get messages about how distracted I was during the presentation. But, I with all of these, I don't have time to do all of them pre-recorded, so I'm probably gonna do several lives. Thank you guys so much for joining. Oh, thank you for the new subscription. And yeah, if you have any questions before I sign off, I know I missed some along the way, but after this is a good question. Oh, nope. What's moving? This always happens to me. I'm really uncoordinated about this, trying to get the one I'm trying to get. Um, Now where to go? Someone asked about Dewey. I think it rolled up. Do we get to see the depositions after the trial's over? No. No, depositions are usually they're just part of the evidence. It's very, very rare that one gets put out there in the wild for us to actually see. The best we'll get is if we do get to listen to the trial, which I'm hoping, I know we won't get to watch it because it's not allowed in federal court. But I thought it was promising that early on Judge Lyman let us listen to the hearings, and I'm hoping that means he's going, "Oh, Buster got married. I saw that. I saw that." I hope she's ready to take that on. She got to see what she's in for. How's my knee? I am in physical therapy now and starting to walk unassisted finally. Did somebody say bots? Oh, there's that bot, Lauren. Thank you for asking. Yeah, it was a long process. Next week is finally 8 weeks where I should be able to resume, most things, but I am in physical therapy now with it. And that is helping a lot. Right now, they're strengthening the areas around the knee to help support the knee. So that's good. Ryan Reynolds pays your and you spend it all on Pacer. Pacer's expensive, isn't it? It gets crazy. I was there when you were talking about you got your first bill because it's quarterly, and these documents are monstrous, and there's so many. But yeah, it's shocking. It's funny when people say stuff about us YouTubers making money off of this. I'm like, if you saw what I pay for paper, because I have to print everything, I have to see it on paper. I'm not good at screens. And if you saw Pacer, and you got to buy a good microphone and sound equipment. I've got a custom built PC because I make the videos, and that requires a lot of extra stuff. Not just any ordinary PC can handle that. I have a EcoTank printer and buy reams and reams of paper. It's like, what money do you think I'm making here? It's crazy. Let's see. Yeah, Pacer is so expensive. It really is. People have no idea. And if you get to past 30 pages, they don't charge you past that. But how the files are broken down, it will be like there will be a document and then like 10 exhibits. So each exhibit, you start paying for over again. It's you pay for per page, and it's outrageous. All right. So we have Leanne and um, Lauren, two other content creators in the chat. If you guys, HP Inc. back to school commercial is free. Yeah, I got the Epson Eco Tank. It's my second one, and I love that. You just buy the bottles of ink and pour it in, and it lasts so much longer than those stinking cartridges. Yeah, the lily in the book. Let me click on these. The lily in the book didn't have any money. How did she afford designer clothes? Well, Blake, who didn't read the book, decided that since she owned a flower shop, she apparently was wealthy. So that's what happens when you don't read the book. You don't know what your character's supposed to be. Yeah, we have a star-studded chat. All right, let's see. Let's see. Oh, thank you. Yeah, I have a whole episode about that because it just drove me crazy. Because it when you just hear stuff, don't just run off and repeat it. Like, sit and think about it. Does it make sense? Does it add up? Do some research. So, like what they were saying about the smear campaign, Justin and Jamie, they wanted this film to succeed. They're the last people that wanted a smear campaign right when they were releasing it. If they wanted to smear her, they would have waited till long after the movie was a success and then tried it. And they wouldn't have done stuff that would link it back to themselves. They would have found completely, they wouldn't have talked about her clothes in the movie. They wouldn't have talked about her marketing campaign. They would have deflected all of that, both for the preservation of the movie. And so it wouldn't be connected back to them. It makes no sense when you actually sit and logically think about it. There's Katie Paulson. Oh, let's see. Oh, inherited the money. Yeah, but it didn't look like, I mean, it was definitely a comfortable family, but not the kind that, when you just open up a business and it's not running well, that you can afford all that kind of stuff. Oh, I did it again. It keeps moving. Yeah. I hate that he's getting unfollowed now. He wasn't for so long, but he's starting to get unfollowed now, just since all this started happening. Once the sham lawsuit was uncovered and all this, they really clicked into high gear. Exactly. They had 5 years and so much money invested. This movie meant so much to him. Why would he have wanted it to fail? A sugar daddy on the side, perhaps. Yeah, we but to be honest, we haven't had him rule on hardly anything. Yeah, so I don't feel like we have a good pulse on how he's gonna rule. Yeah, you guys too. You guys are amazing. You keep me doing this. Trying to Yeah, they could be removed from the case. That's one of the possibilities. And then she would be faced with getting all new attorneys. It's one of the possibilities. But it all depends on how he views this. Yes, and see, and I'm glad you said that, because I believe it had so much to do with not just having legal access to this stuff, but the New York Times article. And I really think that the the stay that's on the New York Times the stay that's on the New York Times discovery right now, I feel like it needs to be removed now that, um well, that's true if yeah, yeah, there's a lot of possibilities of how this could be taken care of. But, what was I saying? Oh, I lost myself. Oh, the New York Times. That discovery needs back open back up because now that we have this, we need to know when was the New York Times contacted? Was the sham lawsuit because of them? Did she? Because we know that she went to them in October and gave them the documents. We don't know if she'd already attempted to go with them with a story and they said, "You need this. You need to do this first." So, yeah, she looked like a hobo. I wouldn't be caught dead in those clothes. Not that I'm a fashion plate, but, um, I feel like this opens it should open, the New York Times back up because I feel like yeah, that. Did you go to the New York Times and then get told you have to come back with a subpoena, and then we can look at this? And if that happened, did they have this idea of how to get it? Were they in on it at all? Did they know what she was doing? Did they see at any time this lawsuit? Because, to show actual malice, and I have this big report I've been working on in the background about actual malice because it is such a sticky topic. So I've got like this huge amount of research I've done that I want to make a thing on. But we're also talking about not just public figures. So the actual malice standard, it could be for Justin, but what about these other people? And I feel like it all needs to be revisited, knowing what we know about the sham lawsuit. Because I mean, I know they try to get out of it saying that, well, it's not our responsibility to do this. There's so many rulings that if you say, oh, it's because you were negligent, there's so many case laws out there that say, well, that's not enough. And if you say, well, they were biased, there's so many case laws, you could say that's not enough. But when you accumulate all of this together, it's a whole different story. And that's the cases that I found. By itself, each accusation will not stand up. But if you bring all of this together, it's a different story. And like I said, that Rolling Stone article that resulted in two separate lawsuits. Well, one was successfully fought in court, and the next one they ended up settling because they ended up not having the protection of it. So yeah, that's one of the points I really want is to see if this affects the New York Times because they've not been dismissed yet. They're still waiting for their dismissal, but their discovery has been stayed, and I feel like they probably have some really important discovery to help prove this sham lawsuit. Let's see. Exactly. Because like I've said before, I've got this little YouTube channel, you know, but when I'm going to report something, I do so much research. I try to be as careful. That doesn't mean I don't make mistakes, but I try to be as careful as I can possibly be when I'm going to say something. And here's the New York Times, and they're going to put out an accusation like what they put out. And they didn't look at the lawsuit. If I was told that someone had a subpoena, if they bring me a story and they say there's a lawsuit and there's a subpoena, I'm going to ask for the subpoena and I'm going to look the lawsuit up. I'm not going to just read what they hand me. I'm going to look at the lawsuit and on the actual website, and they didn't do that. And I don't understand. So this was also trying to say. Okay, so the 17-point list is different than the no more list. So, and that's one of the things that people get that Team Blake uses to say that Justin admitted to these things. There was like a 30 no more list that was never given to them. Blake read it off. They didn't even think of it as a document. When she had everybody come to their place and they screamed at them, the Sony rep was there and everything. She read off, no more this, no more that, but never provided them with a document. The 17-point list was about like requirements for her to return to filming. And those were all just things that most of which they'd already been doing on set. It was things like the intimacy coordinator. And then there were some new things like she was supposed to have a Sony rep with her on the set at all times. That was one thing that's not required that they didn't have, but then they agreed to do. That was the 17-point list. There was nothing in that, and they signed that because they're like, we don't have a problem doing these things. These are normal things most of them were doing. The no more was the awful stuff, the accusations. And that was never signed. Because people say, well, they signed that no more, and that's them admitting that they did it. But those are two separate things. The no more didn't even show up as a document until she filed her complaint. Then it showed up. But they hadn't even seen that in written form. So let's see. All right, guys, I am going to, how long have we been on here? Almost 2 hours. So I'm going to end this. But thank you guys so very much. And I don't know how to go back and find the super sticker. Oh yeah, there it is. Sorry, I'm still learning all this. Thank you, Rihanna. I'm not sorry if I said it wrong. And also Fred, thank you very much. And thank you very much, Ellen. Thank you guys so much. And everyone just for joining and supporting and all of the wonderful comments that you leave here. You're the reason I keep doing this. And I love sounding off about this and finding, people who feel the same, and we get to sound off together and be heard by each other and hopefully spread the word of this injustice. That's just really a crime. And I hope that's what it's found to be in the end. But anyway, have a wonderful weekend. And now I'm back to the rest of this mountain of documents I got to get through. And also, Leanne is covering not just on Twitter. She's also covering some of this on her YouTube channel. Thank you very much, Shannonos. I hope I said it right. I'm sorry if I didn't. Thank you so much. She's covering it on both places. She gets to these much quicker than I do, and gives a nice layout of these documents and what they mean. And Lauren is the fastest person on the internet. As soon as these come out to Pacer, she knows and she's on it, and she is reading them off to you. And it's great. So if you don't already subscribe to those people, they are definitely worth subscribing to. Just to hear Lauren's laugh is worth it, as she gets through these, and she gets outraged at all the right places. And yeah, she does a really great job. So thank you guys again. Have a wonderful, wonderful weekend, and I will see you soon.